Hi guys, it's Kathy. I hope you're doing well. Lori, hi Lori. I'm getting a weird echo in my headset. I don't know if you guys can hear an echo or not, but we're gonna go through it. It'll be fine. It's just an echo. So, welcome to Sunday night. Oof. All right, I got some court for you. This is a pretty interesting one. We're gonna start there. Kind of reminds me of Bobby. I don't know why. Here we go.
Your Honor, we're ready with Mr. Brown.
Thank you. Court will call 26 CR 820 Brown. Mr. Brown, can you state your name for me, please?
Larry D. Brown.
Mr. Brown, did you either watch a video advising you of your rights or receive a written copy of those rights?
Did.
Do you have any questions about your rights?
Do not.
Mr. Berkey, what is the people's position on bond?
Your Honor, this is a FOJ out of Texas where the defendant is being charged with first-degree murder. I don't believe that the court has the Texas arrest affidavit, but that was provided to our office through the Lamar County Sheriff's Department. This is a cold case from 1981 that was reopened for investigation by Texas law enforcement in 2025. It's alleged in their case that back in 1981, the defendant was having an ongoing financial dispute with a young woman regarding some property, and was also attempting to get her to assist him in essentially some insurance fraud, and she was refusing. This culminated with what appears to be an extremely violent assault, where the defendant entered the woman's apartment, had an extremely violent altercation that culminated with him strangling her to death with an electrical cord, and she was found later that day by her boyfriend. The defendant's DNA is tied to the victim's bloody clothing that was recovered. When the investigation was reopened, Texas law enforcement worked with the Lamar County Sheriff's Office to obtain the defendant's DNA, since he was living in Loveland, and tied him to the crime. So obviously, it's about as high as the stakes go. The Texas warrant is for $2,000 cash. I would request a $2,000 cash only warrant here as well, along with GPS monitor.
Mr. Sheldon?
Yes, thank you, Your Honor. I made a similar record on a different FOJ case earlier today. We object to this case even being heard right now, because even though the district attorney is telling us that they've received this documentation has not been provided to the court. And it's not been provided to you, Your Honor, or to me, or my client. And there is a specific unambiguous law, section 1619-104, that establishes the form of the demand. We need this paperwork by the time we go to court to confirm that this is a legitimate and real demand from the state of Texas. Now, I'm not in the business of calling people out for fictionalization or whatever, and that's not what I'm here to do. But there are laws that we're supposed to be following. This is an institution that is a organ of our rule of law. And if we're going to be holding people accountable for breaking the law, then we must be equally responsible for following the law. And if we don't follow the law, then we are no good than any other rule breaker or law breaker. My client is a attorney. He is a longtime resident of this state. He's an upstanding member of this community, and he deserves to have law followed, just like any other person who is called to court is entitled to the law being followed in due process of law under Article 2, Section 25 of the state constitution, as well as the 14th Amendment of the United States Constitution. The form of the demand is insufficient. It's unsatisfactory. All we have in front of us, Your Honor, is a boilerplate, fill in the blank waiver of extradition and a bond application, and then a complaint and information that alleges my client violated the law by being subject to extradition. So I don't even know why a complaint and information has been filed here, because it doesn't accuse my client of actually breaking the law in Colorado. It doesn't raise a claim that is justiciable to this court. So, Your Honor,
Sir, did you miss the murder part? I think that's a crime. Oh, is murder not a crime anymore? That would make sense. That checks out.
these aren't just technicalities. This is the law, and all law is technicalities. The state of Colorado as a legal entity is a technicality. The state of the United States of America is a technicality. And so we have to follow the law. We have to satisfy the form of the demand in order to extradite my client. I am not able to sit here, and the court is not able to sit here as well and receive a waiver of extradition here, because we don't even know if this is a bona fide extradition. The state of Colorado has told us that they've received this information, but that doesn't matter. It needs to be filed in the court. 1619-104 lays that requirement out very plainly, and that has not been followed here. So, Your Honor, we would be asking for the court to release my client based on this, defect in the proceedings. If there is an active warrant out of the state of Texas that is extraditable, then he's going to have to answer to that. But he has to answer that in a proper form, and that has not been established here today. Setting that aside, we would be asking for the court to release my client on a personal reconnaissance bond or a $1,000 cash or surety bond. He is, again, a 80-year-old man, lawyer, practiced in Colorado for 35 years. He is an upstanding member of this community. He has extremely deep ties to this community, and a personal reconnaissance bond that could allow him to return voluntarily to the state of Texas on his own dime would be appropriate here, or to raise his rights and to exercise his right to extradition in the state of Colorado while not confined to the jail. Your Honor, we don't even know what he's charged with. The state of Colorado says that it's a first-degree murder, but all I see in front of me is homicide, which is, technically a medical determination. It is not even telling us what he's accused of in the state of Texas. I think that this is a proceeding that's defective on its face. We would ask the court to dismiss this proceeding due to failure to comply with 1619-104, or to at least release my client while this is litigated further before the trial court division. Thank you.
Your Honor, I would just note that in every FOJ case, it is by nature of an FOJ case an out of state charge rather than a crime committed within the state of Colorado. And I would point out that our affidavit is attached with a notarized affidavit from an investigator attesting to the charge.
Your Honor, in other jurisdictions, they filed the entire packet. In the 13th Judicial District, we never had this issue. The DA's office has always submitted well, not always, but they submit the warrant and etc. There doesn't need to be a petition or a complaint and information here. That's not done in the 13th Judicial District. It's not a statewide policy. And even if it was a statewide policy, not following the law is not the law. So a custom of just not following the law does not create in and of itself a new policy that we can just circumvent the law with. Thank you.
Pursuant to 1619-117, the court does not find that Mr. Brown is eligible for bond in this matter, given the pending charges. The matter will be set in with Judge McDonald in courtroom 4B. The first appearance is June 23rd at 8:30. Mr. Berkey, is there anything further?
No, Your Honor.
Mr. Sheldon, anything further?
No, Your Honor, thank you.
Great, thank you.
Wait, what? Judge, you didn't hear what he said? You didn't listen to anything that lawyer said? Good job. Now some friendly neighbors, which I don't have to worry about anymore, right, Tiff?
Afternoon. This comes on for a court trial. Is the prosecution prepared for trial?
Yes, I'm ready to proceed, Judge.
All right, Ms. Cox-Koshak, are you ready for trial?
Yes.
All right, ma'am, you can take a seat at the defense table and we'll get started. Mr. Dingus, does the prosecution wish to make any opening statement?
No, Your Honor.
Ms. Cox-Koshak, do you wish to make an opening statement?
Yes, I do.
All right, you can get up to the podium and make your opening statement to me of a limit of 5 minutes.
Okay. Dear Judge, I respectfully submit this letter to provide context regarding the circumstances that led to the criminal mischief charge currently before the court. The sign involved in this matter was located on property that I understand to be my own. For an extended period, the sign created a recurring problem affecting my privacy and the use of my property. Individuals who saw the sign would frequently drive down the easement toward my residence, believing it was the correct destination. Upon reaching the end, they would discover a neighboring gate, realize they were in the wrong location, and turn their vehicles around in my backyard. This situation occurred repeatedly and resulted in strangers entering areas where I stored personal belongings, tools, and construction equipment. I had previously requested the issue be addressed and that the sign be removed, but those requests were not acted upon. On the day in question, 2 separate vehicles entered and turned around in my backyard with approximately 1 hour of each other. After experiencing this ongoing problem and feeling frustrated by the continued intrusion into my property, I made the decision to paint over the sign and decorate it. My actions were not motivated by malice, vandalism, or a desire to damage another person's property. Rather, I believed I was addressing a persistent privacy and safety concern that had been affecting me for some time. I respectfully ask the court to consider the circumstances, my understanding that the sign was located on my property, my prior attempts to resolve the issue, and my concern for the privacy and security of my home and belongings. Respectfully.
Thank you. You can go ahead and have a seat again. Prosecution may call its first witness.
Thank you, Your Honor. The people will call Deputy Klink.
All right, that witness may come forward to the witness stand. You may come forward to the witness stand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
You may have a seat at the witness stand.
And can you please state your name for the record and spell your last name for the recording?
It's Deputy Angela Klink, Klink.
And Deputy Klink, are you a patrol deputy with the Pueblo County Sheriff's Office?
I am.
And were you working in your capacity as a patrol deputy at on October 21st of last year at about 4:25 in the afternoon?
Yes, sir.
And at that time, did you respond to a report of property damage at 333 Park Drive, located in Pueblo County?
How many people make fun of her name when she tries to arrest them? All of them. Every single one of them says the same thing.
Yes, sir.
And is that neighborhood essentially on the other side of Pueblo Boulevard from City Park and the swimming pool?
Yes, sir.
Okay. And when you went there, did you speak to the reporting party, Greg Alfonso?
Yes, sir.
Okay. And had he called police because his sign had been spray painted by his neighbor?
Yes, sir.
Did you see the sign?
I saw pictures of it. Yes, sir.
Okay. And what did what did it look like?
It still had some gray spray paint on it.
Okay. And where was the sign located?
It was towards the end of the road on the outer edge of his property.
Okay. And was this a was this kind of, can you describe, was this like a custom made sign?
I believe so, yes, sir. He said it was made by the correctional facility several years back.
Okay. And did it have his last name on it?
Yes, sir.
Okay. And did and when you contacted Mr. Alfonso, had he attempted to clean the sign?
He did.
Did he show you a picture of what the sign looked like before he had attempted to clean it?
I believe so, yes, sir.
Your Honor, I'm showing a picture. May I approach?
You may.
And does this look like what he showed you?
Yes, sir, it does.
And that's a picture that he took to show you the damage that you guys took.
Yes, sir.
And that's a true and accurate copy of what he showed you?
Yes, sir.
Your Honor, I would move to admit People's Exhibit 1 at this time.
All right, Ms. Cox-Koshek, do you have any objection to the admission of Exhibit 1 into evidence? I'm sorry. Okay, Exhibit 1's admitted.
And did Mr. Alfonso mention that this kind of area between the two houses had been subject to some dispute about where the property lines were?
He did.
And he believed the sign to be on his property.
Yes, sir.
I have no further questions on direct.
All right, cross-examination, Ms. Cox-Koshek, it's your chance to question this witness if you would like
Okay.
to.
It's an ongoing dispute, and there's no question about that. I don't have any questions for you. I saw the sign. I
Okay,
did the sign.
this is not your chance to make a statement or to testify. It's your chance to ask her
I don't
questions.
have questions.
You don't have any questions for this witness? Okay, may this witness be released?
She may be released.
Any objection to her being released, Ms. Cox-Koshek?
No.
You may step down and you are released.
Thank you.
Prosecution may call its next witness.
Your Honor, the people's next witness is Deputy McCormick.
That witness may come forward to the witness stand. You may come forward to the witness stand. If you could raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? You may have a seat at the witness stand.
Good afternoon, sir. Could you please state your name and spell your last name for our recording?
Deputy Cody McCormick. Last name is McCormick.
And Deputy McCormick, are you a patrol deputy for the Pueblo County Sheriff's Office?
I am.
Okay. And were you working in your capacity as a patrol deputy back in October of last year?
I was.
And do you remember on the speaking with a Mr. Greg Alfonso on October 21st about someone spray painting his sign?
Yes,
Okay. And did you go to, and was that at 333 Park Drive?
yes, it was.
Okay. And is that within the county of Pueblo?
It is.
Okay. And did you go to the property after Deputy Klink had gone there initially?
I don't remember if it was before or after.
Okay. And did you attempt to speak to Miss Cox Koshank, the next door neighbor who is alleged to have spray painted the sign?
Yes, I did.
Okay. And is she present in the courtroom today?
Yes.
Can you identify her by stating where she's seated and identifying the color of clothing she's wearing?
She's to your right with the blue shirt.
And
Just one more reason why I should not mow. Right, Prissy? Thank you so much. I just won't mow. You know what? Grass doesn't get that high. We'll just let it go.
when you asked her if she had spray painted the sign, did she admit to it?
Yes, she did.
Okay. What did she say about doing it?
She said something about spray painting it with, I think, pretty flowers or something.
Okay. And did she claim that the sign was on her property?
She did. She said that it was on her property.
Okay. Thank you. I have no further questions.
Tiffany, if you're still here, did you see that? Kelly said we should get a goat and some chickens.
All right, Ms. Koschek, do you have any cross-examination questions for this witness?
I have no questions, thank you.
Okay, thank you. Mr. Dingus, may this witness be released?
He may be released.
Hold on, just hold on a second, sir. Any objections to him being released from his subpoenas, ma'am? You may step down and you are released.
Thank you, Your Honor.
Wildflowers, yes.
Just a second. All right, prosecution may call its next witness.
Thank you, Your Honor. The people's next witness is Greg Alfonso.
All right, that witness may come forward to the witness stand.
Oh well, guys, Tiffany's the only person in the world that can boss me around, so I don't get any chickens.
You may come forward to the witness stand right here. And before you sit down, can you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I was more worried about... Wait a second. Shut up, JK.
I do. You may have a seat at the witness stand.
I was more worried about the snakes, actually. I don't care about the rats. I have cat.
And good afternoon, sir. Could you please state your name and spell your last name for our recording?
Greg Alfonso, Alfonso.
And what is your, what's your address?
333 Park Drive.
Okay. And back in, on October 21st of last year, did you have a sign that was vandalized at your address?
I did.
Okay. And so can you describe to the court a little bit just where this sign is as far as the layout of your property goes?
The sign from my house is approximately 100 yards from the Park Drive. My house sits west 100 yards. It looks like a road, but it's actually my drive. And you can't see my house from Park Drive. It sets back that far.
And so, it's fair to say this sign's kind of at the end of where your driveway would be.
Correct.
Okay. And can you describe what the sign is and where you obtained it?
Sure. Back when I bought the property, I worked at Territorial Correctional Facility, and a good friend of mine.
Oh my God. I'm so excited that I'm even talking while I'm chewing. That's how excited I am right now. Bill, I miss you. I do. You have texted me twice since I moved, and at both points I was in the middle of something. I didn't text you back right away, and then I didn't text you back. And I miss you, and I wanted to talk to you both of those times. I had things to say, and that's all right. But I'm glad you're here. Hi, Bill. Bill is here, guys. I'm very famous. I'm very, very famous. I'm so famous. Bill from American Courts comes and talks to me and sends me text messages that I love.
Ran the sign shop at Territorial Correctional Facility, which makes all the street signs for most of the cities
Oh
in
my
Colorado.
God, Jen,
And
I
a good
love
friend
you.
of mine says,
Hi,
hey, you
Jen.
know, you need a sign so I can know where your house is at. And he made that sign for me. So I've had it basically since I've been there.
Okay. And
We're currently watching Judge Simpson in Michigan, Bill. You don't know that? Silly.
was it, what did the sign say on it?
Alfonso Drive.
Okay. And so prior to the day of October 21st, had your neighbor, Miss Cox-Koshenk, and yourself had some dispute about the property lines in that area?
We have, and I pay the taxes on it. She seems to think it's an easement.
And was it your understanding that the sign was located as part of your property?
No, it's not on my property. It's on Pueblo County's property. My mailbox is on Pueblo County's property.
Okay.
From the street, there's, an offset from Hart Drive. In fact, Mrs. Cox's mailbox is on county property too.
Okay. And then prior to this date, you never, may sound like a silly question, but you never gave Ms. Cox-Koshenk permission to spray paint or damage the sign in some other way?
No, none whatsoever.
And can you describe to the court how you discovered that the sign was spray painted on that?
I have a privacy fence back at the end of, the start of my property where my house is at. You don't even know my house is there because of the property privacy fence. Anyway, I'm getting ready to leave. That's the only way in and out of my property. And I pulled down to the end of my drive to Park Drive, and there's a 2-3 foot step ladder. I didn't actually visibly see Miss Cox spraying it, but there was a step ladder and she was standing there talking to, I'm not sure who, but she still had the spray can in her hand.
Okay.
And I even asked her, I said, what are you doing?
Okay. Did she tell you what she was doing or no?
No, she didn't. In fact, whoever she was talking to, I think it was some relation. A younger gentleman in his early 30s wanted a piece of wanted to cause me some physical harm.
But that looks just like Judge Simpson, doesn't it?
Okay.
If it wasn't for Mrs. Cox stopping him, I'm sure he would have.
When you saw her standing next to the step ladder with the spray paint can, did the paint on the sign appear to still be wet?
It was.
Okay. And then, so after she damaged your sign, did you obtain an estimate about a cost to replace the sign from Kaiser Innovations?
I did.
Okay. And was that estimate for $172?
That sounds about right, yes.
Okay.
Oh, that's my mistake then. Oh, that's right. I don't do Michigan courts. I don't do YouTube judges here. I only do stuff you cannot find on YouTube. Therefore, you can only see these judges on very few other channels. You can only see them here. We've seen this judge before a couple times. She's very, what's the word I'm looking for? Strict is not the word I'm looking for. Unemotional is not the word I'm looking for. But it's a cross between those two. Strunemotional. That's what she is. Jen, thank you so much. I appreciate it. Thank you so much. You know what I'm going to do with that, Jen? Because you are you. I'm going to buy something to plant outside in my yard. And if you tell me, don't say corn, you tell me what I should buy to plant out back in my yard. And I will.
Those are my questions on direct.
All right, any cross-examination, Ms. Cox-Koshak?
No.
All right, may this witness be released, Mr. Dingus?
Yes.
Ms. Cox-Koshak, do you have any objection to this witness being released from his subpoena? You may step down and you are released from your subpoena. Any other witnesses, Mr. Dingus?
No, Your Honor.
All right, is prosecution resting?
Yes.
All right, Ms. Cox-Koshak, the prosecution has rested their case. At this time, you have an opportunity to make any legal motions called a motion for judgment of acquittal. Do you wish to do so?
Yes.
All right, go ahead and make your legal argument for that.
Well, I don't have a legal argument. I have my statement from before.
No, you've already read your statement. You said
Okay,
that was
that's
your
all I have.
statement. You don't have any legal argument as to why I should dismiss it at this time?
Well, the sign, I believe, is on my property.
Anything else?
No.
Okay, thank you. All right, does the prosecution have any rebuttal argument to that argument?
Judge, you should be very careful, because I have a feeling she's going to want to speak to your manager if you don't rule right.
Shall I sit?
You can sit or you can stay standing. You can sit down again if you'd like.
Your Honor, I would argue even, I mean, first at this point in the trial, there's no evidence to that fact in the record. So I think the record establishes that the sign was damaged by the defendant based on her admission that was testified to, the testimony of Mr. Alfonso.
I think, Hanky, that she thought she didn't need an attorney because it's on her property. She can do anything she wants with it. That's what she thinks. And she's pretty much a Karen. She doesn't like that sign because someone touches her driveway. And if something touches her driveway, that's an offense towards her. So she thought she could just go to court and tell the judge what to do. And that's what she's doing.
Deputy Quinn. And I'm sorry, I didn't present the courtroom.
Oh, thank you. All right, when determining a judgment for motion of acquittal, the court is to determine whether the relevant, direct, and circumstantial evidence, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. When determining a judgment of acquittal, acquittal, the prosecution must give the court, I'm sorry, must give the prosecution the benefits of every reasonable inference which might be fairly drawn from evidence. In this case, when I look at the evidence as a whole and in the light most favorable to the prosecution, the evidence is as follows. Greg Alfonso owns a sign that says Alfonso Drive, that it is placed on Pueblo County property. It is a sign that he got from a friend of his who ran the sign shop at Territorial Correctional Facility. It says Alfonso Drive on it. On October 21st, 2025, as he was leaving his property, he saw a 2 to 3 foot step ladder by the sign, and the defendant had a spray can in her hand. There was damage to the sign, and the paint on the sign was still wet. He asked her what she was doing, but she didn't answer. On October 21st, 2025, at approximately 4:25 p.m., Pueblo County Sheriff's Deputy Angela Klink responded to 333 Park Drive on a property damage report. She saw a sign that had she saw a stop sign that said Alfonso Road. She spoke with Greg Alfonso. She was shown a photo of what the sign looked like before there was any damage by Mr. Alfonso. Her understanding was it was a custom-made sign. She saw the sign on the end of the road and saw photos of gray spray paint on it. Also on October 21st, 2025, Sheriff's Deputy Cody McCormick also responded to 333 Park Drive and spoke with Greg Alfonso. He did speak also with the defendant who identified in court. He asked the defendant if she had spray painted the sign. The defendant admitted to it and said she spray painted it with pretty flowers on it. She said it was on her property. When I look at the standards for determining a motion for judgment of acquittal, I am finding that when you view the evidence as a whole and in the light most favorable to the prosecution, it is substantial and sufficient to support a conclusion that the defendant is guilty of the charge beyond a reasonable doubt. The motion for judgment of acquittal is denied. All right, Ms. Cox-Koshik, you will have a chance to put on a case, but before you do that, I need to advise you regarding your right to testify, or conversely, your right to remain silent. Do you understand? You have the right to testify. Do you understand that if you want to testify, then no one can prevent you from doing so? Do you understand that if you testify, the prosecution will be allowed to cross-examine you? Do you understand that if you have been convicted of a felony, the prosecutor will be entitled to ask you about it and thereby disclose it to me? All right. Do you understand that upon cross-examination, the prosecutor may ask you what any prior felony convictions were for? Do you understand that if the felony conviction or convictions is disclosed to me, then I can only consider it as it bears upon your credibility, and that I can only use the conviction for that purpose? Do you further understand that you may be cross-examined by the prosecutor concerning any matters which are relevant and material to this case? Do you understand you also have the right not to testify? Do you understand that if you do not testify, then me as the trier of fact cannot infer your guilt from the fact that you remain silent, that it is still up to the prosecution to prove every element of the charge to me beyond a reasonable doubt?
Okay, I don't know what happens from here. Oh, I do. But what I mean is, when I say I don't know what happens from here is, eventually they're both going to have to go back home. And they live right next to each other. And this has happened. Ugh.
Understand that? Do you understand that the decision to testify or not testify is yours personally, and only you can make that decision? Do you further understand that even though anybody else may disagree with your decision, that the decision is yours and yours alone? Do you fully understand this advisement I've just given you? Is there anything further you would like for me to explain to me concerning your right to testify or conversely not to testify? Have you made a decision as to whether you will testify or not in this case? You do not want to testify. Okay. Is that a free and voluntary decision on your part? Is it your own personal decision? All right. Has anybody pressured you in any way to make that decision? Have you talked about that decision with anybody else that you wanted to talk to it about? Okay. Is there anybody you want to talk to that decision, talk to about that decision? No. Okay. All right, I will find that Ms. Cox-Koshek has made the decision that she will not testify in this case. I am finding that it is a knowing, intelligent, and voluntary decision that was her own personal decision, that it was made without any kind of force or undue influence, thereby being voluntary. All right, Ms. Cox-Koshek, do you wish to present any witnesses? Okay. All right, then we are that's the conclusion of the evidentiary portion then. Mr. Dingus, does the prosecution wish to make any type of a closing argument?
Very briefly, Judge, Your Honor, I think the evidence in this case has shown beyond a reasonable doubt that the defendant is guilty of criminal mischief. It's clear that this sign was the property of Mr. Alfonso, and she damaged it, whether it was placed on, I mean, right now, the only evidence before the court is that the sign was placed on county property. It's clear that she damaged it. There was a confession by the defendant to Deputy McCormick. The court has a photograph of the evidence that corroborates it being spray painted silver, as the court can see in Exhibit 1. There's clearly a sign that's been spray painted silver. It's clearly caused some amount of damage. And so therefore, I believe that the people have proven this beyond a reasonable.
Thank you. Ms. Koshek, would you like to make a closing argument?
Yes, ma'am. Believing that that sign is on my property, my rights to privacy, I'm firmly convinced, are being stomped on by people using my backyard to turn around and look at all my, it's actually my mom's front yard and my backyard. That's all.
Great, thank you. All right, I will make the following findings. They're very similar to my findings at the motion for judgment of acquittal. The only evidence presented in front of the court today is from the prosecution. The defendant did not even question any witnesses. So there is no other evidence in front of the court. The statements by the defendant are argument only. They are not evidence for the court. I will find the following. Well, I do find that testimony presented by the prosecution was credible. When I look at all the elements of the charge of criminal mischief, I am finding that the sign belonged to Greg Alfonso. The only testimony in front of the court is it's on Pueblo County property, which that's the only evidence in front of the court. That sign was damaged by the defendant. Her statements show to me that it was knowing. She told Deputy McCormick that she had spray painted it. She was standing with a can of spray paint right next to it when Mr. Alfonso left. And the sign is spray painted totally silver instead of the Alfonso that it did say. regardless of what her reasons were, which are not in evidence. She did spray paint it. I am finding the prosecution has proven beyond a reasonable doubt as well that the aggregate damage was $172. The sign is totally obliterated by the spray paint, and so replacement value would be the value of the sign, which is $172. When I look at all of the elements of the charge, I do find that the defendant is guilty beyond a reasonable doubt. The judgment of conviction enters. Mr. Dingus, is there anything for the prosecution for sentencing?
Your Honor, and I don't know if the court would permit Mr. Alfonso to address the court. I think the primary issue in this case, Judge, obviously this is just a petty offense, so the court's options are for sentencing or somewhat limited. I think the biggest thing here is there's clearly kind of an effort by the defendant to kind of take things into her own hands in a situation like this through means outside of the legal process, like vandalizing the sign. And I think that is actively disrupting Mr. Alfonso's, ability to coexist without issues with his neighbor. I think the court has seen disputes between neighbors before. I think we probably all wish that they didn't exist, but there is one in this case. And I think if the court can just fashion a sentence so that Mr. Alfonso is repaid restitution and to try to impress upon Ms. Cox-Koshenk that, any sort of dispute she has with her neighbors can't just be resolved by taking matters into her own hands to vandalize his things or other things like that.
I have a motion for restitution in the amount of $172.16. Is that, are you still requesting that?
Yes.
Okay. Sure, if Mr. Alfonso wants to say something to the court, that's fine. He can come on up to the podium.
He's been waiting
Your
his
Honor,
whole life. He's been waiting his whole life for this moment. For as long as he's sat next to her in that house. And everything she's said to him day in and day out. And all of her moaning and complaining about him. He's been waiting for this. Let's see if it's good.
More than the value of the sign, it has some sentimental value to me. And it was only marker, you can't see my house from Park Drive. That way, if I did have company, they knew where to turn. But as far as it's just a bad situation. That's all I have to say.
All right, thank you. All right, Ms. Cox-Koshenk, you want to come on up to the podium? Is there anything that you would like to let me know before I impose the sentence in this case?
No.
All right, what are you asking me to sentence you to? I have a variety of options. You can get up to 10 days in jail. You can get a fine up to $300. I can place you on probation. And as a condition of any sentence, I can order restitution. So what are you asking me to sentence you to?
Restitution.
Okay, that's it? Do you want to be placed on probation?
No.
Do you want to go to jail?
No.
You want to pay a fine?
No.
All right, anything else you would like to let me know before I impose the sentence?
No.
Are you in agreement with the amount of restitution requested, $172.16?
That's fine.
No, it's not. He just said the sign was made of marker. It was made of marker. No, $172 is too much for a sign made of marker.
All right, Ms. Cox-Koshenk, what the district attorney said is right. This is not how you handle problems. You do not take them into your own hands. If you believe that there is a property dispute and Mr. Alfonso's things are on your property, then there is a legal way to get that determined, and that's the way to do it. Not to get out a can of spray paint and damage something that's not your own.
Tiffany, I hope you heard what the judge just said. No more spray paint.
You know, lots of people live by people that they don't like, and they don't do anything. Basically, just ignore him if you don't like him or what he's doing. But taking this into your own hands is not the way to handle this. On your finding of guilt, I'm going to sentence you to pay a $300 fine. Plus, you are to pay restitution in the amount of $172.16 to Greg Alfonso, and court costs are imposed. Good luck to you, ma'am. I hope not to ever have to see something like this with you in court again. Once the clerk will have your sentencing documents for you. As soon as those are ready, she'll call you up, and that tells you how to pay the fine and the restitution. Good luck. Ms. Cox-Koshek, don't leave. She'll call you up when the documents are ready, okay? All right, we'll be in.
Is that her family with her?
Okay, we are back on the record in 20.
No, ma'am, you're done. You need to calm down, Judge. We're done with you. We're moving on to a different judge.
All right.
Joined us by WebEx from Valor.
All right, let me grab him. Mr. Malberg, this is Judge Zink. Can you hear me all right?
Yes, I can.
All right, great. I'm going to open the record in your cases. The court's going to open the record in 24 CR 2885, 25 CR 2375, and 23 CR 1086. All those cases are captioned the people of the state of Colorado versus Brandon Malberg. The court notes for the record that Mr. Malberg appears today via WebEx. His attorney of record, Damon Cassens, is here in person. This matter comes before the court on a preliminary hearing in 26 CR 1086, a hearing on probation in the 24 case, and arraignment in the 25 case. How are we proceeding today?
We are continuing the preliminary hearing. Mr. Malberg is still in Valor, so I really haven't had a chance to talk to him about this. I did let the people know that was our plan. We also needed to address the terms of Mr. Malberg's bond this afternoon.
Okay. Are the people in agreement to continue the preliminary hearing?
Yes, Your Honor.
All right, and then what do we need to address about bond?
Primarily, Your Honor, the bond that was granted was so he could go to Valor and undergo the restoration process. He has been restored and opined restored and found restored. And he has sort of reached the end of his stay there at Valor. And the question then becomes this: where does he live? He does have, and his grandmother is here and can confirm this. She does own several properties here in town and has made one of the rentals available to Mr. Malberg to live in by himself. So there will not be any contact with the complaining witness in this and several of the other cases.
And so what is your request, that I allow him to do that when Valor's done?
Correct, and Valor is done.
Okay, where is he? Is he at Valor still, though?
He is currently still at Valor, so the terms, and Valor allows patients or residents to stay past the finding of competence until they have other living arrangements made. But we're now at the point where Mr. Malberg either needs to live somewhere else out of custody or return to the county jail, and is fairly obviously Mr. Malberg's wish is to remain out of custody. He has otherwise complied completely with the terms of Valor. It's my understanding, at most, he only had one write-up the entire time he was there, and there's never been any sort of allegation of him quitting the program or walking away.
What's the people's position to this?
Note that he was originally given a $25,000 cash surety property bond, Your Honor, before the PR bond that was agreed upon between myself, Mr. Cassens, and Judge Curtis. It was my position at that time that I would only consent to a PR bond upon him being released directly to Valor. Now that he has been restored, I would request that a cash surety, if he is going to leave Valor, then a cash surety property bond should be in place because these cases are violent. I have concerns for the victim's safety, given the nature of the two open cases we have with the same victim, his brother, Joseph, in which we have an assault in the second degree bodily injury with a deadly weapon. And then we have assault in the second degree reckless serious bodily injury with a deadly weapon. In both cases, the defendant is alleged to have used weapons to attack his brother and cause injuries, felony level injuries. And then furthermore, he was on a deferred sentence at the time that he committed the first one. So I don't believe that Mr. Malberg is appropriate to be given a PR bond if he is not released to some facility. That was the only condition that I was willing to consent to that PR bond. And I would also note that I believe the brother, Joseph, may be present. Yeah. And so he may have some words regarding bond as well.
Is Mr. Malberg taking his medications as prescribed? Do we know?
To the best of my knowledge, Your Honor, he has been medication compliant. Specifically, what I can tell the court is I haven't received any indication from Valor that he has not.
Brother Joseph, are you Joseph Malberg? Where are you? There you are. Hi. Did you want to be heard today in regards to bonds?
I did.
If you could come up to the podium so I could hear you, that'd be great.
Hello.
Hi.
As far as bond goes, I do not believe that my brother is well, how should I put this? I do not believe that he is a compliant member of society currently. As much as I would love to help him and say that, like as he blatantly asked me recently when he was on the phone with my grandmother to plead the fifth or lie, I cannot do that. I sit here as somebody who was violently attacked by my own brother and can say that if he's willing to act that way towards me, I'm 100% certain he's willing to act that way towards somebody else. I love my brother. And as much as I don't want to see him get prison, and as much as I would love to see him get any kind of halfway house like I'm in or probation, I've been through so much over these past few years that I can't sit here and say that it's a good idea for him to just be set free again. Because as far as I'm concerned, he does not understand the consequences of his actions. He's been given many chances over the years where he was given a deferred sentence, or his very first assault charge was a misdemeanor case where he went through probation and got off and then did it again, and then did it again, and then did it again. I don't see a world where if he's let off again, he's not going to just sit there and think that there's no consequences. Do I want my brother to see some freedom? Absolutely. But I also don't think that just letting him go constantly is going to help him realize that he's done wrong. I do want my brother to realize that he's done wrong. I want my brother to get proper help. I hope that he's willing to get that help himself. And if by any measure that he is willing to get that help himself, then I am honestly fine with him getting a bond. But if he isn't, then I am not. If he is shown, like I've heard him over the phone speaking to my grandmother. To me, it does not seem like his mindset has changed whatsoever. And that bothers me.
Oof. Oof. What he's saying is not easy to say. It is not an easy thing to do. He's doing great.
Is king, then she can file into the guardianship. Sorry, I apologize. Somebody's unmuted themselves.
But like I said, if he's shown and willing to show that he's willing to get that help himself, then I don't have any problem with him getting any kind of bond.
Thank you. I appreciate that. I know it's not easy, especially when it's your brother.
I'm also a bit panicky myself at the moment, so
You're okay. You did a great job. Thank you.
thank you.
At the end of the day, the court's considered the bond factors of 16-4-103. The court notes it didn't hear anything. What'd you say?
May I please add something on that regard to where
Do
it's
you
like,
want Mr. Malberg?
Brandon,
No. Everything you say can be used against you, so let's, please don't make statements, okay?
okay,
Your attorney's here and you can talk to him later.
okay.
Okay. The court notes that, the court didn't hear anything about Mr. Malberg having an employment. The court notes that he does have family relationships. He has a grandmother who obviously still is willing to provide him some housing. His brother and him have a little bit of a difficult relationship right now based upon the alleged allegations against Mr. Malberg. The court notes that these are that the complaint and information in each case are the one is a class 4 felony. It's a crime of violence. We also have another matter. Trying to find it. Another complaint and information of another second degree assault, crime of violence with menacing. And then we're already on a deferred judgment and sentence for a class 5 felony of menacing. All of these are violent crimes. The court's concerned and agrees with Mr. Joseph Malberg that there's a concern that he's acting like this to family. He's going to act like this to other people. Well, I'm glad he's restored to competency and I'm glad he's had the Valor program. I do think that he's not appropriate for a PR bond at this time. The court has to consider to make sure that we protect the safety of the people and the community, as well as considering that Mr. Malberg's conditions of bond do need to be reasonable. And so in the probation revocation case, I'm gonna, so upon his release from Valor, his PR bond will be revoked and he'll need to come back to the jail unless he can post his bond. The court will order in the probation revocation that that bond could be set at $3,000. That's in 2885. In 2375, the court will order that the $10,000 bond will be reinstated. Court will reduce that to $5,000. And then in the 1086, the court's going to order that that bond would be set at $20,000. The court will make those cash, corporate surety, or real property. The court will order that he would meet with probation within 24 hours of his release, and he would take any medications. I'm trying to see the other ones. No drugs or alcohol, or no drugs while on out on bonds. And so the court does note that and makes those findings at this time. With that in mind, we need to reset our prelim. When are you requesting that to be reset, Mr. Cassens?
Within 35 days.
Okay. I could do either June 15th, June 22nd, or the 29th at 1:30? Which do you prefer?
The 29th.
All right, we'll do the 29th at 1:30. The people accept that date?
Yes, Ron.
All right. Anything else from everyone?
I
Not
love
at
the
this time.
drinking game.
All right, court will be in recess. Court is going to open the record in two El Paso County cases, 2019 CR 6413 and 2025 CR 4386. Both those cases are captioned "The People of the State of Colorado versus Dylan Ringdahl." The court would note for the record that Mr. Ringdahl appears today in person in custody with his attorney of record, Mr. Callahan. These matters come before the court for sentencing in 25 CR 4386 and then resentencing in 19 CR 6413. Mr. Callahan, how are we proceeding today? Okay, are the people ready?
Yes, Your Honor, Shelby Crowe appearing on behalf of the people. We are ready to proceed.
All right, Ms. Crowe, we'll start with you then.
And probation, Ms. Halfling is present. I don't know if she wanted to make a statement. No. Okay, easy enough. Here we go. So in 25 CR 4386, the defendant did plead guilty to count 1, internet sexual exploitation of a child. We have an agreed upon sentence of 6 to life.
What? Sorry. Unbelievable. I always cut these out. I always do. Every time. And I have strict rules with my software to delete it before I even see it half the time. I have these programs that delete these so I don't even see them. And, so last night my car broke down and I was stuck in Lancaster forever. I got home so late that I didn't watch all of these clips before I played them. I just trusted that my software was going to save me, and it really just didn't. I don't want to play that. Alright, here's what we're going to do, guys. We're not playing that. I don't want to hear it. I don't. I have her. We're going to play her. We haven't seen her in a while. It's a 2-hour docket, so I'm just bumping it ahead to here. Let's see. Nope, I'm going to bump it ahead to here.
Get out on community corrections from leaving the Indiana Department of Corrections after completing the purposeful incarceration program, and do not.
Yeah, my new car, my alternator went bad. It's fine. I bought a new alternator today, but they didn't have one in stock, so I ordered it, and it'll be in tomorrow. And it's good news, Kelly, because I can't drive anybody anywhere tomorrow because I don't have a car. So I can sit and I can get my stuff together and unpack a little bit more and maybe sleep a little bit.
Do so well because they, for whatever reason, do not heed my warning. I'm going to hold you to a higher standard. I'm going to require you to comply with all terms of community corrections, which include that you not have any contraband at your house. So if it's your house, your mom and dad's house, your spouse's house, your sister, your brother, your cousin 3 times removed, a close friend, a neighbor that you just met, anything in that house, including any outbuildings, garage, anything that would be on that lot is all attributable to you. Okay. So you should search that house like your freedom depends on it, because it does. So look in the back of the Lazy Susan, look in the nooks and crannies of the garage, the basement, places that people haven't gone in years. If there's cupboards above your refrigerator, there's anything above your refrigerator, search through it. That drawer underneath the stove where some people put miscellaneous pots and pans, any place. I had somebody that I sent back to the Indiana Department of Corrections because somebody decided that beer was beer hiding place was good to do it in the laundry room. So look everywhere.
Okay.
So then, again, that's on a zero tolerance basis, which I've explained to you. You are going to participate in any additional evaluations, evidence-based practices, treatment programming, and or rehabilitative programming deemed appropriate either by Elkhart County Community Corrections or your treatment provider. I'm going to order that you obtain an addictions assessment and follow any recommendation. So within the first 21 days after your release from the Indiana Department of Corrections, you're going to obtain a sponsor or recovery coach and give that contact information to your case manager at Community Corrections. Seek out support groups for addictions such as Alcoholics Anonymous locally or online, or Narcotics Anonymous locally or online to find a meeting or any other 12-step meeting program that is approved by your case manager. Schedule an appointment for your addictions evaluation and give that contact information and the provider to your case manager. So within the first 90 days, you are going to attend.
They're not looking for. Well, they might be. He's going to do like home. He's on probation, or he's being sentenced. To house arrest or whatever. So, he's not allowed to have anything in his house at all. So she's just warning him there better not be anything in his house. He can't say, "Oh, but I didn't know it was there," because she just told him to check everywhere.
90 AA or NA meetings or any other 12-step meeting program approved by your case manager within 90 days of your release from the Indiana Department of Corrections. And you're going to give that proof of attendance to your case manager as they direct you. So if they want it daily, weekly, monthly, that's how you're going to provide it to them. And then within those 90 days, you're going to provide a copy of your addictions assessment to your case manager, and you're going to follow any recommendations. I understand that you've just completed an intensive, for lack of a better phrase, inpatient treatment. However, I want to make sure that you have sources that you can rely on if you become, I guess, complacent, or you think that you are going to turn to either drugs or alcohol to violate any of the conditions of this order. That way you have somebody who's familiar with your case that hopefully
Hi,
you can
Mary.
get into quickly.
Hi.
And be able to be dissuaded from doing anything that would send you back to the Indiana Department of Corrections. Because that's the quickest way to get back to the Indiana Department of Corrections, is to imbibe in either drugs and or alcohol. So during and after the 90 days from your release, you're going to continue attending AA or NA meetings or any other 12-step meeting program approved by your case manager 2 to 3 times per week or more, if either recommended by your case manager or your treatment provider. Read recovery literature daily and apply it to your personal life. Spend time with associates who are in recovery, but stay away from associates who are using. Maintain your support network. Apply the methods that were developed in your relapse prevention plan and your safety plan in order to help you avoid returning to substance use or criminal behavior, and continue revising that plan as needed. Also, you should utilize your any identified community resources to aid in your recovery. Spend quality time with family, but stay away from family or friends that are using either drugs.
I just heard stay away from family or friends. Done. Got it, Judge.
Or alcohol. Do not go into any place where the primary function is to sell drugs or alcohol.
Okay, that's it. I'm never going to be a criminal because that's just too harsh of a punishment.
tell all healthcare providers, including nurse practitioners, mental health professionals, and dentists of your status as a recovering person. Do not use any drugs that have not been prescribed to you by a legally licensed physician who is aware of your status as a recovering person. And you're going to obtain gainful and legal employment. Do you understand the conditions of your release?
Yes, I do.
And you understand that I'm trying to keep you busy so you stay away from familiar faces and familiar places that will lead you back to what got you to the Indiana Department of Corrections to begin with.
Yes, I do.
So I'm going to release you from the Indiana Department of Corrections on July 16th, 2026. You're going to report to Elkhart County Community Corrections no later than 24 hours after your release from the Indiana Department of Corrections. So I'm going to set this matter for compliance hearing on August 6th, 2026 at 1:30 p.m. If you have been hooked up with community corrections no later than July 17th, which would be within 24 hours of your release on July 16th, then community corrections will send me either a notice of arrival or your signed terms and conditions of community corrections. Then my staff will vacate that period of August 6th of 2026 at 1:30 p.m. If for any reason you are not hooked up with Elkhart County Community Corrections by July 17th, you must appear on August 6th at 1:30 to tell me why the first thing that I told you to do, you couldn't do. And I'm going to tell you that there is no good reason why you cannot be hooked up with Elkhart County Community Corrections by July 17th, other than you just want to go back to the Indiana Department of Corrections, because I will be more than happy to oblige you. Issue
Thank you,
a
Kelly.
warrant and send you back to where I found you. You understand that?
I understand.
We're going to order a credit time memorandum to include any additional time accumulated while you were at the Indiana Department of Corrections. Do you understand? Do you have any questions?
No, I don't, Your Honor.
And do you understand what I expect of you?
Yes, I do. I do have a question. I'm sorry. The 90/90, can I please do that online, or do I have to go to, because the meetings I was going to before, to be honest with you, there's a lot of people that don't take that serious.
Right.
And, my recovery to me is everything. I have been sober off of meth for almost 7 years, and it will be 7 years in December. And I'm very proud of that. But I need to know if you're okay with the online.
Yes, you can do it.
Go
in
ahead.
person. I'm okay with online.
All right. Thank you.
You're welcome. And in the order that I'm signing here in a second, it has the websites for the online.
All right. Thank you very much for that.
So, some people like the in-person, some people like the virtual online. Whichever one you think will assist you in your recovery, that is what you shall do.
All right. Thank you very much, ma'am.
All right. Good luck, and hopefully we won't see each other again.
Yes.
Thank
you. Have a good day.
You too.
Thank you.
Do I need to do any more?
Beer pong, no. Cornhole, yes. Oh wait, I don't have my cornhole stuff anymore. I left it behind.
All right, well, here,
I
we'll
forgot.
sneak you in. Thanks. Yeah. Who's your client?
This is Don Schaefer, Your Honor. Donald Schaefer.
There you are. All right, this is cause number 2602F414. This is State of Indiana versus Donald C. Schaefer. Mr. Schaefer, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
I do.
Thank you. And sir, can you please state your full legal name for the record?
Donald Christopher Schaefer.
And sir, what is your current address?
53601 Hyde Park Drive, Bristol, Indiana, 46507.
Date of birth?
7/30 of 1971.
Last four digits of your social security number.
9274.
All right. It looks like we're here for a status conference. We don't have any future dates. And it's Ms. Embler, correct?
Yes, Your Honor.
What's the status?
Your Honor, procedure wise, I am unsure how this court compares to the other courts I practice in as to setting trial dates. I would like to go ahead and just get some trial dates on the calendar, so there is a potential end date for all of this for my client.
Sure.
The goal is obviously to get this resolved without having to go to trial, but
Let's see, do you want my first available trial date?
depends on how soon that would be.
Let me look.
If it's next month, no, Your Honor. I have 2 minutes.
Usually I don't, like if it's 30 days out, I don't. So it'll be sometime in July 23rd, 25th, or whatever date it is today.
Okay, Your Honor, I would probably prefer end of September, early October.
I'll CR4 then.
Yes, Your Honor.
All right. Any objection from the state?
No, Your Honor.
All right, so. I do have September 28th available as an out of custody major felony.
I cannot do that week, Your Honor.
All right, so it's gonna be October something. Let's look.
Do they start on Mondays here or Tuesdays?
All jury trials start on Monday.
Okay.
And I anticipate 3 days.
Yes, Your Honor.
No, and they can always be less than 3 days.
Right, that's preferable.
But more than 3 days interrupts with my normal Thursday calendar. So my October out of custody major felony is October 26th.
Yeah, that's fine, Your Honor. I'm open all October.
Okay, so Mr. Schaefer, we're setting your jury trial for October 26th, 2026 to commence in this very courtroom. If you fail to appear for any reason, we'll have the trial without you. You will not have the opportunity to confront or cross-examine your accusers as guaranteed to you not only by the US Constitution, but also the Constitution of the state of Indiana. You now have the ability to aid your attorney with your defense. You'll not have the ability to cross-examine any witnesses, and you'll be bound by a decision that is reached by the jury in your absence. Do you understand what will happen on October 26th, 2026 at 9:00 a.m. if you fail to appear for any reason?
Yes, Your Honor.
We're also going to set it for a pretrial conference then on October 8th, 2026, and that'll be at 1:30 p.m. right back here. Do you find the need for me to put it for a status between now and October? If the need arises, you can always petition the court. We'll sneak in.
Okay, Your Honor. I appreciate it.
All right.
Thank you.
Thank you. I'll CR4 to defense.
If you have questions afterwards, you can sit and wait. Otherwise, you can go.
Is that the only one you had, Miss Embler?
It's not, Your Honor. I have one more. The cause or case number is Kaylin Baker. However, my client is Jermisha Baker.
Yes. All right. It's encompassed in 2310 F229. This is State of Indiana versus Kaylin Baker. However, the related cause is Jermisha Baker. Miss, am I pronouncing your first name right?
Yeah.
So Miss Baker, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
I do.
Thank you. And ma'am, could you please state your full legal name for the record?
Jermisha Baker,
And what is your current address?
531 Concord Avenue, Elkhart, Indiana, 46516.
Date of birth?
8194.
And the last four digits of your social security number.
No.
Your cellular telephone number. Thank you. What's the status?
Your Honor, I would prefer to handle this case once the criminal charge related to this case has been handled. That's got a hearing set for July 28th, I believe.
So do you want me to do it like a couple weeks after that? A week after
Yeah,
that?
I will probably ask for trial dates in that case as well. I'm someone that likes to get my cases moving and done.
Great.
Yeah, July 29th, she's got a status hearing in that case where I'll be setting trial dates. So it's up to the court as to when they would like another status on this one.
Ms. Fair, do you have any opinion on when you'd like status?
After that is fine.
We can do it the next day.
That should be fine.
The
July
30th.
July 30th?
I'm here almost every Wednesday and Thursday except for July
When's the
30th.
next time you're here there, close proximity?
After that?
Yes.
Shoot, way too far.
Like I have.
It would be on a Thursday, Your Honor?
Yes, I have August 6th available, August 13th.
I'm going to go further into the docket so that we get something other than just scheduling hearings. All right. We have 5 minutes left in this stream, and then we're going to start it here and play 5 minutes. Here we go.
There may be an issue with Mr. James's hearing.
Yes.
So, and I don't know if that was addressed today. Or
No, next week.
Next week.
They will
okay.
decide that.
All right. Who do we have?
Working tomorrow.
Okay. Cause number 2112 F340. This is State of Indiana versus David S. Weiss.
Missed half of benefit.
Yep. Yep, that's okay. I have a list. I have a warrant list.
Okay.
Either way, anyone you feel more comfortable sitting at, there's 3 chairs for your seating pleasure. So, Mr. Weiss, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
I do.
Thank you. And sir, can you please state your full legal name for the record?
David Scott Weiss,
And what is your current address?
51444 Kenilworth.
Your date of birth,
11/16/87.
last 4 digits of your social security number, and your cellular telephone number.
574.
Thank you. All right. It looks like there were some outstanding fees owed to Elkhart County Community Corrections in the amount of, back in June, it was $2,360. How are we here? How is that coming out today?
I've steady been paying. I just started a new job. So there's that. I plan on I'm supposed to be getting paid every week, so I'll be making the next payment by next Friday.
Okay.
Um
Do you know what your balance is?
Your Honor, it looks like he was discharged from community corrections.
yeah, I'm on probation now.
Yeah.
Yeah, outstanding fees.
So it looks like, yeah, but his outstanding fees at that time was $2,865.
No, it's back to 2,300 because I made payment.
Hang on.
Right. Sorry.
I think they filed the thing. Oh my goodness gracious.
They filed
They filed the final discharge report and then filed a subsequent May report. So he could be correct.
That's what Leslie gets on me.
I think the
So I just want to make sure that these are
Coming down.
coming down.
They are, man.
So. When do you anticipate that you could have those paid off by?
All of it?
Yes.
Can you give me at least 6 months? I got a lot of stuff going on in my life.
I understand that, but I don't want to keep on dragging you in here just to make sure you're paying.
Right, I understand.
But I do want to see a light at the end of the tunnel.
For sure.
Because Elkhart County Community Corrections provided services for you, which were an alternative to the Indiana Department of Corrections.
Right.
So, you got a benefit? County got a benefit because Elkhart County Community Corrections is our county community corrections provider. So part of our tax dollars go to support Elkhart County Community Corrections. That's why I help them out by making sure they get paid.
Right.
That way all of our taxes don't go up.
Well, I can make, with the weekly payments, I can do at least $250 a week, so with that, it's what, 2.5, 3 months?
Let's see, $250 a week,
Yes, ma'am.
and
Judge, he can't pay $250 a week. Come on. He cannot.
I guess worst case scenario, let's look at what the final report was.
The numbers aren't correct, I don't believe.
That's what I'm saying.
Because if, well, hang on
I'm
a
sorry.
second.
No,
If he recently made a payment since he's been discharged, I just don't think it's updated.
right, no, but they will notify me when it's paid in full, but they don't tell me.
Right.
I just can't say in the worst case scenario, let's say you're lying to me and you didn't make a payment.
Right.
So if you pay $250 a week and it's,
No, I'm saying the following weeks, if I paid it $250, I can have it off in at least 2.5 months.
right, so, but I'm gonna try and give you enough time. That way you don't keep on coming back and all I need to do is see
The balance go down.
How long are you on
balance.
probation?
How long am I on? 3 years, 2 years, reporting 1 year not.
Your Honor, I certainly appreciate his gumption to want to pay $250 a week, but that is extensive, and I don't want to see him fail at
Oh, there's one adult in the room. Thank you.
this. So why don't we just set it for a review hearing in 6 months, and he just, I think, at $250 a week, that would be 3 months.
right.
So that
So
gives you a little
we'll
bit.
set it
of
out for 6 months,
Right.
hopefully. So if I'm gonna have an order to have Elkhart County Community Corrections notify me when everything's paid in full.
Okay.
Hopefully I will get the notification from them prior to December 17th.
December 17th?
Yep.
For sure.
So I'm gonna set it for December 17th, 2026 at 1:30 PM.
So if everything's paid off, I don't gotta come see you, right?
Correct. So I'm gonna order Elkhart County Community Corrections to notify the court when all outstanding fees due under this cause number paid in full. So if you paid it in full, you know how to check my case, right?
Yeah. I'm from
So if you see that the 8th of December 17th hasn't been vacated and you know you paid it in full, then I would go to community corrections and say, hey, can you file something with the court telling them that I paid in full so I don't have to go. All right? Thank you.
All righty.
Have
We
a good
good?
night.
You too. Thank you.
All right, guys. We did it. Thank you so much for coming out today. I really, really, really appreciate it. I'm going to see you all in a couple hours. And we get to do this again. I'm going to get some crazies for tomorrow. Tomorrow morning, I'm going to have some crazies ready for you. I hope that you guys have a good night. I don't know what your plans are for this week coming up. I know the 4th of July. It's a pretty big one. Stay safe. It's just such a weird world out there right now. Stay safe. You know, celebrate smaller. Okay? I'll see you guys in a couple hours. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for